Hello, and thank you for joining us. On behalf of the University of York and local solicitors Crombie Wilkinson, it is my pleasure to welcome so many friends, staff and alumni to our UPlan session. We've got almost 400 people registered with us tonight, which is actually a record for us, and I want to thank you all for that. My name is Marisa Bailey, and I'm the Legacy Manager here at the University, and I provide information and assistance to everyone who considers including the University in their will. Gifts in Wills are funding life-changing opportunities for our students and supporting world-leading research. A recent legacy gift is also helping us to become the University of Opportunity, where we can provide flexible funding to those who need it most. If you would like to discuss leaving a legacy gift or would like more information, please contact me using the email provided. My role also includes planning this free event in collaboration with Crombie Wilkinson. Speaking of which, I am delighted to welcome our speakers today. Richard Watson, who is a practicing solicitor and former Senior Director and Head of the Private Client Team at Crombie Wilkinson, and Belinda Poulter, who is a Director at Crombie Wilkinson. They have very generously volunteered their time for us this evening, and I would love to take this opportunity to thank them for their participation and expertise. A little bit of housekeeping before we start. The session is being recorded, and throughout the presentation, your video will automatically be switched off, and your microphone muted. The talk will last for about an hour, and we'll have time afterwards for Q&A. Questions should be typed into the box at the bottom of your screen, and I'll read them out to you after the presentations. Now, Belinda needs to leave around 6:15. So if you have a question specifically for Belinda, please be sure to let us know. Now let me hand over to our first speaker, Richard Watson. Richard, over to you.
Thank you very much, Marisa. It's wonderful to be here yet again to present this lecture to you, which we hope you'll find useful. Making a will is something which is very important. As Marisa said, I was a solicitor for very many years, but I retired 18 months ago now, I suppose. But I still take an active interest in what is going on. Since we last delivered this speech, there has, of course, been the first budget of the new government. And some of the provisions within that budget are going to have some effect in terms of how people arrange their affairs. I think there's two specific things to say about this. First, the budget is only going to affect a small number of people. But secondly, and here comes the rub, if people are affected, they are likely to be affected to a great extent. We're not going to look at the budget in isolation, but we're going to introduce it into our talk to you this afternoon when it crops up. And the first section, which I'm going to lead on, is in respect of wills and that fundamental question, why make a will? It's a staggering statistic that around about 2 out of 3 people do not have wills, and they are dependent on what's called the law of intestacy. The law of intestacy is that law which engages when somebody dies without the will. And the first reason for making a will is you choose to whom you leave your property. In England, there is no statutory obligation to leave your property to anybody in particular. There are certain saving provisions which we'll come across later on. But broadly speaking, in England, there is the freedom of testamentary disposition. You choose to whom you leave your property. The second aspect to talk about when it comes to a will is that it gives those people who are managing your affairs, the executors, it gives them immediate authority to act. They don't have to wait for approval from the court. It is true to say that for certain transactions, for instance, the sale of property, you will have to obtain what's called a grant of probate. A grant of probate is something it's probably something which many of you will be familiar with, but a grant of probate is basically an authentication by the court of the validity of the will and the power of the executor to act. But the will itself gives the executor the power, and in many instances, it's all that is needed. Another good reason for making a will is that it may be tax efficient. There's all sorts of scenarios where you can arrange your affairs in such manner as to mitigate against tax. And again, we'll touch on a number of these during the talk. When it comes to children, the law says a child becomes an adult at the age of 18. Sometimes people feel that 18 is too young for a child to inherit, particularly if the sum of money is a large amount. And therefore, within the will, you can delay the age at which a child takes. Now, as I said a few moments ago, those people who deal with your affairs and are appointed by the will are executors. And another important distinction with an intestacy is that you choose the people who are going to do that. Whereas with an intestacy, somebody with an interest will take out a grant of what's called letters of administration. That can be very important because you may not feel that those nearest to you are the best people to manage your affairs. For instance, you might want professionals to do it for you. Normally, people talk about executors and trustees in the same breath, and it's just worthwhile distinguishing between the roles. Executors are people who handle the affairs from day one until the estate is administered. It might be the situation that under the will a trust is created. For instance, if a child is underage, they're not going to be able to use lawyer spiel, give a valid receipt for the money which otherwise would be paid to them. That is to say, they don't have the ability in law to discharge the role of the executors. And therefore a trust is created. If a trust is created, it needs people to manage the trust, and those people are called trustees. Usually under a will, the executors become the first trustees, but if the trust is to last for any length of time, it's perfectly feasible and normal that the first trustees retire and other people take over. One question we are sometimes asked is, how do I stand in terms of appointing a child who is under the age of 18 as an executor? And the situation is that a child under the age of 18 cannot be an executor. However, there is nothing to stop you putting in your will a provision that you appoint that child as your executor, be it a sole executor or one of several executors, as soon as they obtain the age of 18. Now, within the will, you will probably deal with a number of types of legacies and gifts. Specific gifts are physical items. So, for instance, you might have a nice ring or a nice watch, which you want to go to a particular person. Pecuniary gifts are gifts of fixed amount of money. Can be in terms of hundreds, can be in terms of thousands. It's worthwhile mentioning at this stage that a gift to a charity is very tax efficient because it will save your estate inheritance tax. We'll be talking quite a bit more about that later on. What is left is your residuary estate, and by definition that is going to be a variable amount because from day to day the value of our estate is going to alter. Money comes in, money goes out. And the residuary gifts are the gifts of that money which is left over. It might all be going to one person. It might be going to a number of people. Frequently, if it's going to a number of people, what they get is dealt with by way of a percentage rather than a fixed amount. So I leave half my estate to Algernon, half my estate to charity. A will is also a very useful place in which you can record your funeral wishes. Frequently, these are merely a simple direction whether you wish your remains to be buried or cremated. If you want to provide more details of your funeral arrangement, the type of service, religious or secular, precise instructions as to interment or the scattering of ashes, perhaps that's best done in a separate side letter, but referred to within the body of the will. So you put a phrase in your will, and I request my executors to arrange my funeral in accordance with a letter of wishes, which I shall leave with my will or with my other important papers. So that's a very quick run through the what goes into a will and why you should make a will. I've talked about trusts, and Belinda is now going to talk you through two of the most significant trusts and the interrelationship with inheritance tax. So over to Belinda.
Good afternoon. Many people can make a straightforward will which will cover their estate and cover their assets, but many other of us will have need to have something more complicated in their will or make particular arrangements which need to be dealt with in a different way. And for that reason, there are two types of trust that we can include in your will. The first type of trust is known as a life interest trust. It has two types of beneficiaries. It has a life tenant. They are the person who has the use of whatever assets are placed in the trust for their lifetime or for until a terminating event, which can be less than their lifetime, and remainder beneficiaries. Remainder beneficiaries are the beneficiaries who will benefit from the assets held in that trust once the trust has ended, and this is often when the life tenant has passed away. A life tenant is a relatively simple type of trust and can be used for quite a few different reasons. One of the main reasons that we prepare life interest trusts in people's wills is to try and protect some of their assets from being all used up for care fees. Quite commonly, when one person goes into care, if there is one person still remaining living in that property, for example, the property assets will not necessarily be looked at to be used to pay for their care fees. However, if the person living in the property then, for example, passes away or leaves that property, then potentially the whole of that property may pass to the person who is living in residential care and may be used to pay for their fees. Now, whilst somebody needs to pay for your care fees, many people want to try and preserve some of their assets to make sure that the people they wish to inherit will inherit something. So putting a share of your property into a life interest trust is something that many people consider. That preserves that share of the house of the person who's passed away first, but retains the full use for the life tenant. The life tenant gets to use the property and including the share that's held in the trust for the rest of their life. They have exclusive use of that share of the property. They can live in it undisturbed. They don't have to pay any rent to anybody. They just have to continue paying the utilities and general maintenance of that property. It doesn't really affect anything going forward. It doesn't change the way they live their life or what they do in any particular way. And many people feel that that's quite important, that that level of control is still there and they're not having to particularly answer to anybody. The remainder beneficiaries will then benefit from that share when that person when the life tenant has passed away, but not until then. So it also provides an element of protection that nobody can try and take that share until the life tenant is no longer there. It can also be quite a useful tool in a will. For example, if the people making the will are on their second marriage and potentially they both have children from their first marriage, both parties, while completely wanting to trust their new spouse, civil partner, may want to make sure that some of their assets will pass to their children, whatever the circumstances. By using a life interest trust in that way, when the first person to die passes away, the assets that they put into the life interest trust cannot then be re-gifted away by the survivor. The assets that are held in the trust will then pass to their chosen beneficiaries. This is a very good reason to make sure that something like a life interest trust is included in a will. I've talked particularly about placing a share of a property into a life interest trust. This is because that doesn't affect what happens with that property, and that property remains as it is. It is flexible in that the person who remains living in the property could downsize and they can use their own share of the property and the share that's held in the trust to be able to purchase a new property. If the property was sold, then the share of the property that's held in the trust would be invested. Now, if it's invested, it can create an income for the life tenant because that income might be more important. And the same with any other assets that you may choose to put into a trust. For example, you may have an investment portfolio and you may have one each. You could place the investment portfolio into a life interest trust. The life tenant would be able to use any income that created during their lifetime. But again, the capital value would be preserved for your onward beneficiaries. The second type of trust that may be useful to include in your will is called a discretionary trust. And it's the word discretionary that is really important. A discretionary trust works on the basis that you have a group of beneficiaries. The group of beneficiaries are all potentially entitled to share in that assets held in the trust, but actually nobody is entitled. The discretionary trust is run by trustees, and it is the trustees who decide who will benefit from the discretionary trust, when, and as to how much. A discretionary trust needs a lot of careful planning as you're making your will, because you need to be sure that your trustees know why you've included a discretionary trust. They need to know how you are seeing that you're going to benefit the beneficiaries that are beneficiaries of the trust. Some of the reasons for including a discretionary trust in your will may be that you have beneficiaries who have a disability. If those beneficiaries are in receipt of means-tested benefits, or if they are unable to manage their own money, you would not want to leave an inheritance to them outright. If you put that inheritance into a discretionary trust and they only received payments at the trustee's discretion, this would not affect their means-tested benefits, provided they didn't receive a regular income out of the trust. You may have a child who is going through a divorce and you're very concerned that they don't receive their inheritance while the divorce is ongoing. If you have a discretionary trust in the will, those assets can be preserved within the trust whilst that's ongoing and can be then advanced to that child once the divorce is complete and all of the financial agreements have been made. You may have beneficiaries who are self-employed and have businesses of their own. Those businesses may be in problem, they may cause problems. It would help if their inheritance was held in a discretionary trust. It would keep it away from a trustee in bankruptcy, and again would ensure that that beneficiary would have some money that was held away from their own personal assets. The same with beneficiaries who may be vulnerable, beneficiaries who may have an addiction, who are just vulnerable to outside influences, and particularly when they come into an inheritance. Again, money can be passed to them as and when they require it, or money could be spent for their benefit, but not actually going into the bank account of these beneficiaries, just to ensure that the money goes to the use that you want it to go to, rather than into the pockets of someone else, into the pockets of, for example, a trustee in bankruptcy, or become a factor in a divorce that may mean that your child doesn't receive as good a settlement as they should. The other side of the use of a discretionary trust is that you may have children who are doing really, really well in life. They may have plenty of money and they may not need your inheritance. From that point of view, they can make the decision after you've passed away that that money could be passed on to their children, your grandchildren. While holding the money in the discretionary trust, it allows the flexibility for the trustees and the potential beneficiaries to make decisions as to the use of that money. A discretionary trust doesn't have to last forever. It can potentially last for 125 years. But equally, a discretionary trust can be distributed immediately on death if all of the circumstances are right and all the beneficiaries can receive their money. It can be distributed straight away. If it's distributed within 2 years of the person passing away, it is read back as if that person's will gave those assets away at that time. So it can be a very useful tool to allow a bit of time to think about the circumstances of your potential beneficiaries and decide how the monies held in the trust are to be distributed. But equally, it is a very useful tool to hold trust monies for the benefit of those beneficiaries, but not to distribute it straight away. A third type of trust, which is a type of discretionary trust and which we don't use quite so often these days, but in some circumstances can be useful, are nil rate band discretionary trusts. A nil rate band discretionary trust allows you to put assets up to the value of the nil rate band into a discretionary trust, and therefore not passing them again absolutely to the beneficiary. This may be, again, a spouse or civil partner. This means that those assets won't form part of their estate on their death, but equally would use up the nil rate band of the first person to die. It gives a lot more flexibility with those assets and acts as a protective element out of your will. One important thing to consider for the use of a nil rate band discretionary trust is that some assets may increase in value fairly quickly. If you put assets that are going to increase in value into a discretionary trust, the increase in that value is retained within the trust rather than in the estate of your surviving spouse or civil partner, which again can be beneficial from an inheritance tax point of view. All of these things would need to be considered carefully at the time you were preparing a will, but they just allow extra flexibility in your will to make sure that assets that you want to leave to beneficiaries go to those beneficiaries while still making sure that people's circumstances are not affected by receiving those assets out of your estate. So that's given you a bit of an overview about wills and the various things you can do with creating wills. Richard's now going to talk to you a little bit about what happens if you pass away without leaving a will. You pass away intestate.
Thank you, Belinda. Okay, we've talked about what happens when you do have a will. So what happens when you don't have a will? I think the first chronological thing to take on board is that nobody has any authority to act until such time as letters of administration are granted to someone. Letters of administration, the equivalent of probate, where there is a will. And they are granted to people who are called administrators as opposed to executors. But to all intents and purposes, they are the same people wearing a different hat. But there's no authority from the moment of death. In an intestacy, you have to wait until the grant is made by the court. That means that there is going to be a delay of at least a number of months before you can apply for a grant, be it a grant of probate or letters of administration. You've got to gather together all the information of the assets of the estate, the values, the balances and accounts, the value of a house, etc., etc. Because when you are making an application, you do have to have regard for the fact that there is a potential of having to do a sort of tax return with the paperwork. These days, once you've submitted the paperwork to the court, and the type of court you're making application to is something called the probate registry. Probate registry, it's part of the High Court. They do tend to take quite a long time in order to process the paperwork. So you are talking in terms of number of months. It might be the situation that a bank or a building society will be prepared to release the balance of accounts to interested parties, but the other side of the coin is they might not. I think one thing you can say is that whether somebody has died with a will or without a will, you are able to arrange a funeral early on. But if you have not chosen the beneficiaries under your will, then the law dictates who the beneficiaries are going to be. And broadly speaking, what we're saying is this, that if somebody is married or in civil partnership, and for the purpose of the law, marriage and civil partnership is one and the same thing. So if somebody's married or in civil partnership and there are no children, then the survivor will take everything. If there are children, the spouse or partner inherits all the personal possessions and something called the statutory legacy. It is a fixed amount of money, and it is £322,000. And finally, they take half of what is left, if there is anything left. Children take the other half equally. If children have predeceased, leaving children, i.e. grandchildren themselves, then grandchildren will take the share their parent would have taken. And again, if there's more than one of them, they take it equally. If there's no spouse or no children, then there's a pecking order of relatives who will inherit. But all relatives have to be the descendants of grandparents, common grandparents. And in fact, grandparents themselves form a class of beneficiary. And you might think, well, okay, in virtually all cases, there is going to be somebody to inherit. If there isn't anybody to inherit, then the estate is said to go to the Crown. Now, it's not to say that the King is going to get your money. He's not. It goes to the Treasury, it goes to the government. It is right to say that law officers in the government do have a duty to cast around to see if there is anybody with a moral entitlement. And that actually leads me on to the most dangerous pitfall which occurs in these sort of circumstances, and that is the unmarried couple. Today, statistically, a very large number of people live together without marrying or entering into civil partnership. And you'll have noticed that nowhere in the list I've talked about are unmarried couples referred to. And quite simply, they're not. So if you are unmarried, the law is not going to allow you to inherit under the rules of intestacy from your partner. There is a saving provision, and that is something called the Inheritance Provision for Family and Dependents Act. And that broadly says if somebody in certain classes feels that either a will or an intestacy does not make proper provision for them, they can make an application to the court. Spouses and civil partners, if they make an application, they can claim a reasonable sum. Other people, children, people who have been maintained, and also unmarried partners who've lived together for at least 2 years can claim for reasonable maintenance. I think you will appreciate very rapidly that this is a nightmare situation, and you can have a family involving an unmarried couple with children. You can get to the situation that one of the parents who's just lost their partner is having to take court proceedings effectively against their own children who would otherwise be inheriting. So I think one of the key messages we say to you tonight is that if you are in an unmarried partner relationship, and particularly if you have children, do make a will. Just one final thing, going back to the aspect of valuation. If you own a house or property, there's 2 ways you can own it. You can own it as joint tenants, or you can own it as tenants in common. Now, there are various distinctions between those 2 types of ownership, but the important distinction, particularly so far as the law of intestacy is concerned, is that if you own as joint tenants, your half share will automatically go to the other person with whom you own the house, irrespective of what you say in a will or irrespective of an intestacy. If you own as tenants in common, your interest will pass under the will, either whatever you say in your will in respect of your assets will apply to your interest in the house. Therefore there's no automatic inheritance. So far as the Inheritance Provision for Family and Dependents Act is concerned, it can actually set aside an interest which is passed because of the joint tenancy itself. So, for instance, if you and, say, a sibling jointly owned a property you might have inherited from parents, say, and you own as joint tenants, but you yourself, you are in a relationship, but you're not married or in a civil partnership, and you have the misfortune of dying and your partner then makes a claim, then your interest in that other property might be something which may be taken into account. I'm sorry if that sounds rather complicated. It is complicated, I'm afraid, but it does very much go back to that fundamental. If you are in a unmarried relationship, do make a will. And with that, Belinda is now going to talk about inheritance tax. And no doubt she's going to tell us about the 2 certainties of life.
Thank you, Richard. I don't know why I get the best job of talking about inheritance tax, but there we go. So there are two certainties in life, and they're death and taxes. And sadly, they do go hand in hand. I always like to start this section by giving you a figure of the inheritance tax receipts. I've just got the up-to-date one of the 9 months to December 2024, and that was 6.3 billion. That's an 11% increase on the same period of the year before, which was 5.7 billion. So that's a lot of inheritance tax. A lot of which a lot of people will be quite disgruntled that they had to pay. The first thing to say is not everybody has to pay inheritance tax in their estate, but sadly, more and more people may have to pay inheritance tax going forward in the future. Partly thanks to our most recent budget, which Richard has touched upon, and just partly because things like property prices are increasing, and especially in an area like York. I know not all of you are in York, but for those of us that do live in this lovely city, we do see property prices holding when in other parts of the country perhaps they don't. So I'm just going to talk you through inheritance tax, and in particular the exemptions that are available for inheritance tax. So the starting point is that each of us have a nil rate band, and the nil rate band of your estate is taxed at 0%. It's not taxable. The nil rate band is currently 325,000, and we each have 325,000 that we can pass to beneficiaries without inheritance tax being payable. That figure has now been frozen until 2030. Your nil rate band means that the first £325,000 of your personal assets on your death are taxed at 0%. Any assets that you have over that amount will be taxed at 40%. Your nil rate band can transfer to your surviving spouse or civil partner. So, for example, if you have a will that leaves everything to your surviving spouse or civil partner, you will pass them also your nil rate band. So when they pass away, they will have 650,000 before any inheritance tax becomes payable. It's also useful to note at this point that a will, for example, any assets that you leave to your surviving spouse, so a will, for example, that leaves all of your estate to your surviving spouse, civil partner on first death, there is no IHT payable. This is due to spouse exemption. However, it's also worth considering that if all of your assets do pass to your surviving spouse, this will increase your estate. So your joint estate would then be all in one estate. So IHT is much more likely to become payable on the second death. And you have the nil rate band and the transferable nil rate band totaling 650,000. On top of that, we now have what's called the residence nil rate band. It's a slightly more complicated exemption where you have an exemption of 175,000, which can be set against your residential property, provided that it passes to your lineal descendants. Lineal descendants, put simply, are your children, your grandchildren, your great-grandchildren. Put more complicated, and to add other people to that bracket, you can include the spouse or civil partner of a lineal descendant, and including their widow or widower. It also includes any child who was or was at any time your stepchild. So again, if you are married or in a civil partner and your spouse civil partner has children and you leave a share of a property to them, you can still benefit from your residence nil rate band. If you have adopted a child, or if you've had a child that's been fostered at any time by you and you leave a share of your property to them, you can also still benefit from the residence nil rate band. The residence nil rate band again is transferable from spouse to spouse. So if I pass my share of my property to my spouse or civil partner, and then it goes to lineal descendants, then they will have twice that amount, 350,000. Added together, this gives us the total of 1 million potentially before any inheritance tax may be payable on an estate, provided that all of these circumstances are correct. So provided that I have a spouse or a civil partner, provided that we have children, grandchildren, potentially great-grandchildren, and we are going to leave our estate or certainly our property or a share of our property to them. There are also some provisions in respect of your property in the residence nil rate band if you've downsized. So you may have had a house worth 750,000, but you had to sell that property potentially to go into residential care, and you don't own a property at your death. You can still claim the residence nil rate band if your estate is passing to these lineal descendants under the downsizing provisions. Or you may have downsized from a house worth 500,000 to a smaller house worth only 200,000. You would normally be only able to claim the residence nil rate band up to that value of 200,000. But again, if you've downsized from a larger property, you can claim the residence nil rate band against the higher amount. So it's a reasonably flexible exemption for inheritance tax, but it does have its pitfalls. Once again, going back to Richard's conversation about being married or in a civil partnership, you would lose your transferable nil rate band in those circumstances, and you would also lose your transferable residence nil rate band if assets pass to a partner, but you are not in a marriage or a civil partnership. You would lose some of these exemptions. You would also lose your spouse exemption, whereby all assets passing to a surviving spouse are inheritance tax exempt. So while neither Richard or I particularly want to go around telling you all that you should get married or enter into a civil partnership, if you're looking at tax planning provisions and looking at estate planning and you're not married or in a civil partnership, it might be worth considering. Another exemption from inheritance tax that is worth mentioning is that if 10% or more of your estate passes to charities and charitable organisations, and by the remainder of your estate there is inheritance tax payable, your inheritance tax is charged at the rate of 36%. So if 10% or more of your estate passes to charity and the remainder becomes taxable for inheritance tax, the rate of inheritance tax payable is reduced by 10% to 36%. So again, something worth considering if you know that you are likely to pay inheritance tax. You can do the maths, you can work it out, and it may be worth giving more to charity to enable you to pay less in inheritance tax, which to some people would be a good thing to do. Touching on the intestacy that Richard talked about, there would be no spouse exemption, which I've already touched upon, but equally where I've talked about stepchildren in terms of the residence nil rate band, stepchildren are not stepchildren for the purposes of the residence nil rate band if again you are not married to their parent or in a civil partnership with them. So there are exemptions out there. You do need to think carefully about whether they are appropriate for your circumstances, and going back to the residence nil rate band, what you also need to remember, and again Richard touched on it carefully, if an estate is over 2 million, there is then a reduction in the amount of residence nil rate band that you can claim. So for every so any estates that are over 2 million, it's reduced, the residence nil rate band is reduced by £1, which can lead to it not being available for some people in that circumstance. Richard is now going to talk to you about other ways in which you can make your estate more tax efficient by the use of gifting and other inheritance tax exemptions.
Thank you, Belinda. And I think we can both remember instances where we've had clients leave our office and go immediately to the register office in order to get married.
We have, yes.
Okay, a number of avoidance provisions within the realms of IHT. And just to clarify, what does avoidance mean? Avoidance means arranging your affairs in such manner so as to minimise the tax liability. It is a perfectly legal thing to do. Evasion is arranging your affairs so as to evade tax, and that is perfectly illegal. What we're saying, and these days, dare we say it, politicians sometimes get their terminology mixed up, and they confuse things by talking about aggressive avoidance as well. So anyway, straightforward avoidance measures. The first one I want to touch on is gifts made more than 7 years before death. The 7-year rule is very much misunderstood by lots of people. The starting point is this: if you give your assets away more than 7 years before you die, there is no tax liability in respect of that gift. If you give assets away in the 7-year period before you die, then there might be a reduction in the amount of IHT involved, and there might not. If it is within 3 years of your dying, there is no relief. After that, the tax rate is scaled at a 20% discount between the 3rd anniversary and the 7th anniversary. But what I will say is that your nil rate band might be sucked up into that. And if it is used in that discounting process, it won't be available to your executors after you've died. And I think that is the point which frequently surprises people. Suffice it to say, if you're thinking of doing this, take some professional advice so you fully understand what is at stake. Turning to smaller amounts of money, everybody has an annual exemption of £3,000. And if you haven't used that exemption in the last tax year, you can bring it forward. You can only bring it forward for 1 year. So that means if you haven't used it last year, you've got 6,000. If you're a couple, it's 12,000. It's a nice amount of money for giving away. Additionally, you can give as many gifts of £250 as you like, not to the same people who've benefited from the £3,000, but otherwise. And on marriage, you can give a child £5,000, a grandchild or great-grandchild £2,500, and anybody else £1,000. So, okay, we're not talking colossal amounts of money, but over a period of time, the £3,000 a year can add up, and it's a useful way of getting money from your estate to other family members, friends, etc. Two other benefits which sort of interrelate are gifts out of income. If you regularly give gifts out of a surplus of income, then those will be gifts not clawed back. In order to prove that there is a surplus of income, effectively you have to have good records or in respect of what your income is coming in and what your outgoings are. So it does really mean keeping a log of those figures as and when the money is coming in and out. Regular giving means it can't be a one-off. It's got to be a series of giving. Now, related to this is the maintenance of family members, certain close family members whom you maintain. Gifts to them will not count from the IHT perspective. One of the most fundamental avoidance aspects is giving to charity. And giving to charity is a complete win-win scenario. If you're giving in your lifetime and you're paying income tax, it means the gift attracts income tax relief at basic rate, normally in the hands of the charity, for instance, the university. If you're paying income tax at marginal rates, it means you can claim the marginal rate back when you do your tax return. It also means any money given to charity doesn't count in terms of the 7-year rule. So a very, very good and effective way of disposing of property. The next items I want to look at are those which have been very largely altered by October's budget. Business property relief and agricultural property relief. It's probably business property relief is probably something which is going to be relevant to a number of people who are listening this afternoon, and agricultural property relief, I suspect, to a few people who are listening this afternoon. Suffice it to say, up until April of next year, there are significant tax reliefs, but they are going to reduce it very much so as of April next year. On the first £1 million of property, business property or agricultural property, there will be 100% relief. So if you like, there's an allowance of £1 million. When you go over £1 million, you will get 50% relief. That is to say that the value of those of that interest will be taxed at 20%. There's been an awful lot in the media about how that is likely to affect farms, which by definition frequently comprise a large area of land and which is worth a lot of money. I certainly haven't read so much about business property, but I can very well see that it's going to have a very significant change to how people approach their tax planning. I think one concept I have heard bandied around, and that is that older family members in the business are probably more likely going to pass over to younger members of the family their business interest, which arguably is not something that they would really want to do. But the tax tail in that respect, to some extent, is wagging the dog. It's early days. No doubt we'll get a lot more detail in due course. There's an additional investment which used to claim significant relief, and that was an investment in the alternative investment market. These are shares in certain smaller normally innovative companies. So long as you had held the investments for a 2-year period, you did get 100% relief from IHT. As of April next year, that relief is going to be reduced to 50%. So the attraction of investing in the AIMS market is going to be somewhat less. The other major heading for the effective budget is pension investments. Now, I appreciate that for a lot of people, they'll have government pensions or big employer pension schemes. But for other people, and I suspect a lot of people listening tonight, they will have private pensions, which effectively means that they have a pot of money, and probably a large pot of money, under the umbrella of a pension wrapper. Up until now, they have been regarded as being outside a person's estate and not therefore subject to inheritance tax. It is fair to say that in some circumstances, in the hands of the beneficiaries from the pension fund, after you have died, there could be an income tax charge. What we've heard from the Chancellor is that from April 2027, so we're talking over 2 years away, that pension funds, unused pension funds, and some death benefits will be brought into a person's estate for IHT purposes. Now, if there's a death benefit, that could be applicable as much to a government big employer style pension scheme as it is to a private pension scheme. And in those circumstances, we normally talk in terms of unused pension funds. The point is, at the moment, we do not know what the detail is, but we can anticipate this is going to be a fundamental change. And it is something people are going to have to take into account when they are doing estate planning. Belinda touched on the reduction in residence nil rate band if your estate goes over the £2 million mark, and there's a scale reduction until all that relief is lost entirely. I think it's fair to say if pension pots are going to be brought into the equation, then a lot more people are going to lose residence nil rate band relief, because by definition, a lot of pension pots are going to be for a significant amount of money, not least because people are going to need a lot of money to live on during their retirement. Now, just to touch on 2 other aspects, and these are death in service benefits and life policies. Let's look at life policies first. What you don't want is a life policy arranged so that when you die, the money is paid into your estate, because if it becomes part of your estate, it raises the chance of inheritance tax having to be paid on the money. Therefore, you want the life policy written in trust for the benefit of another, possibly a spouse, civil partner, children, etc. Different insurance companies will treat policies differently. Some will automatically write it in trust. Some will only do so if you ask them. And I've even known the odd life office query what a writing of the policy in trust is. So I think it's very important to go away and just check your life policies to make sure they are written in trust. The other aspect is the death in service benefit, and that goes back to what I was talking about just a few moments ago. You do not want death in service benefits written paid to your estate for the same reasons for the moment. Most pension funds do not do that, and I appreciate it now. We're only talking about an interim period, probably until April 27. But again, it is something worthwhile checking up on. So I close on a personal story, and that is many years ago when I was a young man and I was just qualified as a solicitor. Today, of course, students walk away with a huge liability. I was of that lucky generation where there was a good grant system, but even so, by the time you got to personal, where you got to qualification, you had an amount of liability behind you. And fortuitously, an elderly lady left me a sum of money. She was a lovely lady. She was born at the turn of the 20th century. Of middle-class stock. She qualified as a nurse. She married a bank manager. The social convention of the day that married middle-class ladies did not work. And I think there was always a sense of frustration. Education was always something very important to her. And I remember on one occasion her saying to me, once they've taught you knowledge, they can never take it away from you. And to my mind, that is so true a statement. And that is one reason why I value so much our universities. And I'm fully aware that accessibility to universities has in the past been, to a large extent, restricted to wealthier children, youngsters from wealthier backgrounds. And I know it's a very important part of the University of York that we move forward on open access, giving everybody with ability the opportunity. And that is why I will be ensuring that my estate has a reduced rate of inheritance tax to 36%. And also a reduced amount of inheritance tax, because there will be a chunk going to the university to help those less fortunate pursue their educational wishes, and hopefully be able to stand in my shoes in years to come and deliver these sort of talks. So that money, which that lady left me 35 years ago, having grown in value, that will find its way to the university in order to support youngsters. Now, just to finish off, Belinda is going to say a few words on loss of capacity and lasting powers of attorney. But from me, I'll say good night.
Thank you, Richard. I don't think it would be right of us to talk about estate planning, to talk about wills, if we didn't touch on what would happen during your lifetime if you lost capacity, because the money, the inheritance that we're talking about could all disappear if you lose capacity and become unable to manage your money, and there is nobody around to be able to look after that for you at that period. So you can make a lasting power of attorney. A lasting power of attorney is a document where you appoint people to manage your affairs, your financial affairs, if you became unable to do. This entails simple tasks like paying bills on your behalf, being able to access your bank account, dealing with your pensions, and even to the extent of having to sell your property if that is required. You can also make a lasting power of attorney for health and welfare. That will appoint people to make decisions such as where you might live in the future, what type of care you might receive. For example, if you'd much rather stay in your own home and receive care at home, if you're not able to express those decisions, you want to have somebody that will express that for you. The health and welfare lasting power of attorney also extends to medical decisions. extends to life-sustaining treatment decisions as to whether you are kept alive or treatment is given to you, or whether you are allowed to just quietly slip away if that is your wish. Both very, very powerful and useful documents to have. The modern lasting power of attorney has a great deal of flexibility in that you can appoint one or more attorneys. They can be appointed jointly or jointly and severally, which means they can act independently of one another if that is more convenient, for example, for small everyday decisions, but for larger decisions, the attorneys may act together. You can appoint an attorney and then you can appoint replacement attorneys who can only act if your main attorney either cannot act because they've passed away, or they have themselves lost capacity, or they don't want to act to be your attorney anymore. So there is flexibility in how you appoint your attorneys and allowing you to have, well, I really want this person to be my attorney, but if they cannot be, then someone else can. They are two separate documents, so you can have different attorneys, people who you know would be very good at managing your finances and who you trust, and people who you know will be compassionate and know your feelings about your care and about your medical care, who you may appoint for your health and welfare lasting powers of attorney. They're the sorts of documents that I always look upon as a bit like an insurance policy. We all hope that we're never going to need this document. The will, we're all going to need. We all know we're all going to pass away at some point. But your lasting power of attorney, you may never need. But there are many instances, and I see these on a daily basis, where you may still have mental capacity, but you just may not want to be going out to the bank anymore. You might feel a bit frightened about ringing up and dealing with banks, insurance companies, policy companies, and you can ask your attorney to do that for you. You're still making those decisions, but they can be actually doing it. The financial world is becoming so much more complicated nowadays, and I see many people who get to a certain age and just find it all a bit bewildering and frustrating. But the attorney can still have a conversation with that person and say, what would you like me to do? How shall we make that decision? They can implement it for you. So alongside a will, a lasting power of attorney is an extremely powerful and an extremely important document, and you really should be considering those as part of your estate planning progress. A few words on why you really should have lasting powers of attorney. If you did lose mental capacity and you haven't got lasting powers of attorney in place, anyone potentially, can make an application to the court to become your court-appointed deputy. The first thing to note is that it may not be the person that you would want to manage your financial affairs or make decisions for you. The second thing to note is that it's a much more expensive process. The time involved, it can be up to a year before someone is granted permission to deal with your bank accounts and handle your financial affairs. And that is such a long time when the world is moving rapidly and you may need care fees paying, you may need rent paying, you may need things dealt with. It's also extremely onerous for a deputy who has to submit annual reports every year and accounts showing what they've spent, what money has come in. The other thing to consider is that a deputyship is not generally issued for health and welfare decisions. The Court of Protection deem that every health and welfare decision is a standalone decision to be made on its own merit. The last thing you would want is people to be making applications to the court every other week, every other month, as to make a decision about your welfare. So, as I say, if somebody does lose capacity and doesn't have LPAs in place, there is a route you can go down. All is not lost, but we certainly wouldn't recommend it. It's complicated, it's expensive, and most of all, it can take anywhere up to a year to be appointed as someone's deputy. So I'll just reiterate for a last time, when you're considering your estate planning and considering your will, you really should be considering lasting powers of attorney and who you would want to be your attorneys in those circumstances. Thank you for listening to us this evening. I hope some of what we've said has been useful. And back to Marissa to see if we've got some questions.
Thank you, Richard and Belinda. That was absolutely brilliant and incredibly thorough, and I learned something new every single time. It's now time for our Q&A, and I'm going to start with a few questions for you, Belinda, because I know you have to rush off. So let me just move these over. Excuse me. Here we go. So there's a married couple with 3 adult children, 2 from a previous marriage from the husband, 1 from the previous marriage of the wife. How can each leave a share to the respective children while also enabling the remaining partner to stay in the home and also to sell the home and perhaps move to another home if they wish? So how best to own the property? Would it be joint tenants or in common?
So this is where the life interest trust provisions really come into play, because you can own your property as tenants in common, so you each have a share of your property that you can leave separately by your will. But by putting your share into a life interest trust when the first person passes away, those assets are then effectively ring-fenced for those beneficiaries that you choose to pass them to. That makes sure that potentially your surviving spouse doesn't change their will and leave all the assets to their own children, which of course none of us would ever do, but sadly can happen. Let's be practical about this. So the life interest trust does still allow the surviving spouse to have the use of that property for their life. So the children from the first to die can't demand that they leave, they can't demand that they have someone else to live in that property, and they can't demand rent from them, but they just have to wait to receive their inheritance until the second of that couple pass away. The person who the second to pass away can downsize. The trust can be moved to a different property. So if that person needs to move, the trust can go with them. The assets are still preserved for your beneficiaries, but it just allows the surviving spouse to have that flexibility to make decisions almost as if the property was theirs. As a family, they would need to work together, but the provisions in a life interest trust, and in particular relating to a property, do allow you to do that. So that's a definite scenario where a life interest trust would be really useful in a will.
Right, and going on from the life interest trust, is the value of the deceased trust set at their death, or as a percentage of the value of the estate?
It's a percentage of the asset that goes into the life interest trust. So for example, if it is a half of a house, then the half of the house would be valued for inheritance tax purposes at the date of the death of the first to die. But if it's held on a life interest trust for the surviving spouse, the actual value received would still be a half of that property, but at the date of their death, which is likely to be more, as in the asset has grown.
Perfect.
Yeah, the only thing I'd add to that is if they currently own as joint tenants, it's very simple to change it to tenants in common.
Yes, thank you, Richard. It is a simple process.
Finally, Belinda, for you, does spouse exemption for inheritance tax extend to unmarried partners if a will is in place?
No, it doesn't. It doesn't matter whether you've got a will or not. There is no spouse exemption if you are not if you are not married or you're not in a civil partnership. So everything that you pass to your unmarried partner is subject to inheritance tax, bearing in mind the other exemptions, the nil rate band.
Right, I think this one's going to be for Richard then. And Belinda, thank you. I know you have to rush off.
You're very welcome. I'll hang around for a little bit,
Okay.
but if I suddenly disappear, then I've gone.
We do have a few international type questions tonight.
Okay.
So, Are there any particular things people need to consider when they have assets, including pensions, in other countries? So we've got an Australian permanent resident in the UK,
Yeah.
and a dual UK-Australian national. They're updating the wills which they wrote living in Australia. So some assets in Australia and some in the UK.
I think the starting point is if you have assets in two separate countries, see lawyers in each of the countries. What is probably the best thing to do is to make a will in the UK in respect of UK assets and a will in Australia for Australian assets. Laws of probate in different jurisdictions will make different provisions. So, for instance, whereas in the UK there is a freedom to leave your property where you wish, in other countries, for instance, France, there is a determined pattern in terms of how property is left. Australia, understandably, follows a legal system which is very similar to ours. But it is going to have its own variations. The other thing to look out for is taxation. Normally, there are arrangements between countries so that estates do not suffer double taxation. I don't say that's always going to be the case. And again, it's something to check out when you are making the wills.
Now, this is an interesting one, and I guess being a university, it might be a little bit more usual than most. I don't know. If you plan to leave your body to research,
Yep.
presumably it should be mentioned in the will. And are there specific details to be included?
It's a very good point. Yes, by all means, mention it in the will, because the will is the document which your executors and perhaps other people are going to look at first and foremost, but also make arrangements with a medical teaching hospital. A provision in terms of the disposal of your remains, your funeral, is not binding on your executors. Most of your will is, but that is one aspect which is not. So talk to your local basically university hospital arrangement, which here is obviously going to be HIMSS, and see what they actually want you to do. Believe it or not, hospitals are quite particular in terms of who they want.
Another question. So if a husband and wife are separated and they don't have children, or
Yeah.
if all the relatives live abroad, what happens if one of them passes away?
Right. Yes, that is a very significant event. If they have gone to divorce solicitors, one of the first things the solicitors will advise is to make a will, make a new will. Up until the time there is a decree absolute, in fact, I don't think they call it a decree absolute anymore, the final decree of divorce anyway, you are deemed married, and insofar as there is not a will, then the spouse will inherit under the normal laws of intestacy. If there is a will, again, the will will be operative. It's worth mentioning, if there is a divorce and you don't make a fresh will after the finality of the divorce, references to your former spouse are deleted from the will, but the will otherwise remains intact. Conversely, if you are married and have a will in place, your will is revoked by marriage. So if you are getting married, make sure you make a will as soon as you're married, or alternatively, you can actually make a will in contemplation of marriage.
Does joint tenant also mean joint ownership?
Okay, we stray into landlord away from probate law, but it doesn't matter at all. Joint tenancy means an equal interest in the property. And it can be more than two people. So, for instance, 3-4 siblings who inherit a house from a parent, they can each have an interest in the property, but by dint of a joint tenancy, the interest is equal. A tenancy in common means people have shares in the property, and it can be in unequal shares. So, for instance, in a business arrangement, it might be that senior partners have bigger shares than junior partners in a property. And I'm afraid, under land law, there is more confusion because property is owned both at law and in equity. And at law, property is always owned as a joint tenant. Forget that, it's the equitable interest which concerns us, whether the equitable interest is owned as a joint tenancy or as tenants in common.
Another overseas question about inheritance tax. Assets in the UK, but does the inheritance tax nil rate band still apply aside from any dual taxation agreement?
What, somebody living overseas with
Yep,
UK assets?
Yeah. But has assets in the UK.
Yeah. I think that's probably a question of domicility. What is domicility? Domicility, it's not nationality. It is that place which you consider your home, for want of a better description on that. Can we let that person, if you can obtain their email address, can we send them an email response on that?
Yes, absolutely. I am thinking at some point or other I might not need to do an international type property session because we get so many of these questions, don't we?
Yeah.
Another question. So if somebody doesn't have lineal descendants, do godchildren count?
No. They need to be specifically named in a will. The law of intestacy is not going to include a godchild.
And another question. I have somebody who's sponsored a family for 7 years with an income. Does this need to be registered with HMRC? It's not done through a charity, but purely on a private basis. I'm thinking that might be more of an accountancy type question, is it? Or
well, it could well be the case that it is, but if it's a straightforward sponsorship of an individual, presumably it's probably somebody abroad in a country which isn't particularly wealthy. That in itself, I don't believe does need registration. If it is a question of IHT avoidance, making sure that it is a payment out of surplus income is important. It goes back to what I was saying earlier, and that is keeping a record of your income coming in, your expenditure going out, so as to demonstrate that there is a surplus of income.
what are your thoughts, Richard? Someone who has not yet made a will, but has no family partner, and would likely fall into inheritance tax bracket due to the value of their property.
Okay, well, by all means, make a will. The danger is that the estate lands up with the crown. The estate is said to go bona vacantia. And you know what, you might think that this is a rarity, but in fact, Belinda and I are currently handling the estate of a mutual friend, and that estate is bona vacantia. That person was the only child of parents who themselves were only children. So no family capable of taking. I think that one of the measures of the test of capacity is that somebody understands moral obligation on their estate, and I think that is it's 19th century phrasing, because that's when the case was decided by the court. But it is those people who you are closely associated with and who it might be reasonable for you to leave money to. So I think I'd look at that. I would look at friends, people whose friendship you've appreciated over the years, those who've helped you along the way on that. Look at charities. If you went to the University of York, wouldn't you like students in the future at University of York to benefit?
If you gifted your property to your child less than 7 years before you needed to go into residential care, but your child had sold that property, would they then be liable to pay for your care up to the value of the house?
If you have made a straight gift, then no, there would be no liability. If it's a conditional gift, the chances are it will be deemed a gift with reservation, and the value will be clawed back into your estate on that. Giving your home to the children willy-nilly is considered inadvisable for all sorts of reasons. You have a fallout, the child goes bankrupt, the child is involved in a divorce, and the asset is taken into account in the divorce settlement. So it's not a good thing to do.
We've only got a few minutes left now, so I'm going to try and do some questions that hopefully are fairly quick. Do spouses have lasting power of attorney automatically, or does it need to be formally established?
It needs to be formally established. And I do know of an instance of a wife of 50 odd years whose view was not taken into account when her husband was terminally ill in hospital. Now, that was wrong, but in those circumstances, it's not the time to have the argument with the hospital.
Another hopefully quick one. Do you need to amend your will every time your address changes?
No, it's useful if the will is. Most solicitors will hold a will for free. And if you are moving out and not using those solicitors for the house move, it's as well to just let them know the change of address. And invariably that letter is placed with the original of the will. So the same goes for beneficiaries.
Oh, right. On the 3,000 gift annual exemption, is that 3,000 per year, per gift per year, or 3,000 in total for all gifts in 1 year?
It is a £3,000 allowance per year, which can go to one person or a number of people. You then have 250, which is, you can give as many 250s as you like. But you can't give those 250 to people to whom you've given the 3,000 or part of the 3,000, if that makes sense.
I've got a question here actually that I probably can answer myself, recommending a free low-cost will writing service. We do have one on the University of York website, and I know there are issues about these online free legal services. We have partnered with Octopus Legacy, and you can find it on the website or message me afterwards and I can give you the details. Crombie Wilkinson have been really great and have offered us a 12.5% discount off their services. And there's an awful lot to be said face to face. Now we're just about at 5:30. So what I would suggest is if you've got any more questions or questions that haven't been answered, feel free to email them to me or include them in the post-event survey, and a link will be magically appearing at the end of this webinar. It takes a few minutes to complete, and I will promise I will get back to you. And this particular session, we run it twice a year. The next one will be in July, so please do come to that. I've mentioned about the discount from Crombie Wilkinson. If you also got any very personal sort of questions that you want to ask them, I suggest you direct those yourself or make an appointment. If you want to take up the offer of the 12.5% discount, please let Crombie Wilkinson know that you've come via UPlan and the University of York. And that's about us for today. So on behalf of the University of York and the Office of Philanthropic Partnerships and Alumni, I'd really like to thank Richard and Belinda and everybody for coming, all our friends, staff and alumni. Enjoy the rest of your evening, and I hope to see you again soon. Good night.
Good night.